Hello everyone, welcome back to another episode of Polity Daily Drill. Today is day 14 and it also marks the 133rd birth anniversary of Dr. Bhimrao Ramji Ambedkar, born on this day in 1891. To start our session, let's reflect on a quote from Baba Sahib that remains profoundly relevant. And he said, "I do not want that our loyalty as Indians should be in the slightest way affected by any competitive loyalty, whether that loyalty arises out of our religion, out of our culture, or out of our language." He further said, "I want all people to be Indians first, Indians last, and nothing else but Indians." Let's dive into our discussion now. First question. With reference to the J&K Reorganization Act of 2019, consider the following statements. According to the Act, both the UTs of J&K and Ladakh are provided with a state legislature. Now we all know very well that as far as the UT of J&K is concerned, yes, it does have a legislature, but the UT of Ladakh does not have a legislature. So one is wrong. Second one, the UT of J&K will have an advocate general to provide legal advice to the government of the UT. This is correct. Like states, the UT of J&K will have an advocate general. The provisions for advocate general are mentioned under Article 165 of the Indian Constitution. So in this case, B2 only is the correct answer. Moving on to question number 2. Consider the following statements regarding adjournment motions. Adjournment motions, just to tell you, Rule 56 of the Lok Sabha rules talk about adjournment motions, and this motion is basically raised to discuss matters of urgent public importance, and when this motion is accepted, the entire agenda, the business for the day, is suspended and the House starts discussing on the matter of urgent public importance. Let's look at the question. First one, such motions can be introduced in the Lok Sabha only. This is absolutely correct. Number 2, at least 100 MPs are required to support the motion. This is wrong. We don't need 100, but we need just 50 MPs to support this motion. Number 3, one unique feature of such motions is that matters which are sub judice, meaning matters under adjudication of court of law. So those matters are called matters which are sub judice. So one unique feature of such motions is that matters which are sub judice can also be discussed in the House. Now this is not possible. In fact, the rules very clearly state that matters under the adjudication of court of law cannot be discussed. So in this case, only one statement is the correct one. Right answer is A, only one. Moving on to question number 3. Which of the following are the qualifications for a High Court judge? So High Court judge qualifications are mentioned under Article 217, Clause 2. I would request all of you to read Article 217 on your own as well. So what are the qualifications here? Here it mentions advocate in the High Court for at least 5 years, judicial officer in the subordinate court for at least 5 years, distinguished jurist. Now, if you refer to this article, and you would know the qualification to be a High Court judge is advocate in the High Court for 10 years, judicial officer in the lower court for 10 years, and there is no concept of distinguished jurists being made High Court judges. This exists only for the Supreme Court. So, none of these are the qualification to be a High Court judge. Right answer is D, none. Fourth question. Consider the following statements regarding removal of Supreme Court judges. A judge can be removed only by an order of the President based on a motion passed by both houses of the Parliament by a special majority. First statement is actually correct. Why? We need a special majority, which is a combination 2 by 3, 2/3 present and voting, and also more than 50% of the total strength, total membership of the House. This similar majority is used to amend the Constitution as well under the provisions of Article 368. Second one, when a removal motion signed by the members of the Parliament is given to the presiding officer, he or she can refuse it. Absolutely correct. The Judges Inquiry Act of 1968, which talks about or mentions the entire procedure with respect to the removal of these Supreme Court judges, does clarify that if at any point of time the motion is given to the presiding officer, he or she may refuse it, may accept it. So 2 is correct. In fact, we have seen in the past that when the motion to remove Justice Deepak Mishra was initiated in the Rajya Sabha, the then chairperson of the Rajya Sabha, Venkaiah Naidu, had rejected the motion, had refused to accept it. Number 3. The committee that investigates into the charges against the judge consists of members of Parliament from both the houses. This is wrong. See, whenever the removal takes place, whatever charges, allegations have been leveled against the particular judge, they are inquired into by this inquiry committee, and hence the name Inquiry Act. This inquiry committee comprises of judges and jurists. So it's a 3-member committee comprising of the Chief Justice of India. If he is not there, then some senior Supreme Court judge. The second member would be a Chief Justice of some High Court, and the third member would be an eminent jurist. So it is not the MPs who are a part of this committee, but the judges themselves. So 3 is wrong. How many statements are correct? B. Only 2 statements are correct. And the last question for today, question number 5. Consider the following provisions. Free and compulsory education to all children of the age of 6 to 14 years. Provision for early childhood care and education, ECCE. So, provision for ECCE to children below the age of 6 years. And number 3, duty of every citizen to provide education to his or her child. Which of the provisions mentioned above were added through the 86th Amendment to the Constitution? So this number 1 is nothing but Article 21 capital A, which is the right to education, added under Part 3, Fundamental Rights. This was added under Article 45, DPSPs. Though initially DPSPs contained this provision, a modification was made and it was done to replace the original provision with the new agenda, new target, that is providing early childhood care and education. The state shall endeavor to provide ECCE to children below the age of 6 years, and this one is a fundamental duty, Part 4A, Article 51, capital A, Clause K. All 3 were added through the 86th Amendment Act of which year? Of the year 2002. Hence, all. D is the right answer. That brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me. Jai Hind.